Good afternoon or morning or whatever, wherever you are. Hello. Hope everybody is well. Hope you're enjoying the weekend, all of you out there. Jack Hamilton, Toe Cramp, the one, A ADELAP third, Born Free, Matthew, Mark. What else do I see here? Gator Boy, Renee. Hope your Canadians do something. They may not. Vegas looks like the best team, in my opinion, but that's just my opinion. Hope everybody's well. Not legal advice. This is not legal advice. All opinion, all the time. This is a follow-up or a continuation of a series of live streams about GTII and the goings-on by someone who is trying to pay attention to what's going on and offering opinions about what's going on. Today, I'm going to talk about, and I think I mentioned it the last time I was going to do a filing, and I did. I'm going to go through the filing, and I'm going to go through a little bit about a discussion I had with a large shareholder. I don't mean that he was tall or that he was overly fat, but he's a large shareholder. And then some thoughts and stuff, whatever. Last time, the last live stream I did, I used Claude to generate kind of Claude's view. And I also used Claude to generate the jokes. And today, just as a, we're exploring AI here. So we're testing out, some people, because I was listening to a podcast this morning. Some people think that biotechs and medical companies using AI, they'll be able to do crazy things. We're not talking about crazy things here, although I guess we might be talking about crazy things. But I'm using AI to see which AI has a better sense of humor. So last one we used Claude, and we got Claude jokes, which were kind of Claudy. And today we're going to get Gemini, which is Google, Gemini, and we'll see how you guys like their jokes. So today's jokes are about receivers, and you could prompt the model if you want it to go in a particular direction. So I did ask specifically for biting jokes about receivers, just to be fair. So this wouldn't be all the jokes I don't think that Gemini would give, but for my instructions, these are the jokes that it gave, and now you could evaluate which one you like better. Why did the receiver get excited when the company went completely bankrupt? He realized he could finally charge his highest hourly fees to count the empty boxes. How many receivers does it take to change a light bulb? Only one, but they will charge the estate $500 an hour to sit in the dark and draft the illumination plan. 3, a receiver promises to save 20% of a dying company's assets. The business owner asks, for the creditor? The receiver laughs, no, for my administrative fees. Number 4, why are legal receivers always so calm during a financial disaster? Because no matter who loses everything in the courtroom, the receiver still gets paid first. And last but not least, what is the difference between a legal receiver and a vacuum cleaner? The vacuum cleaner eventually gets full and stops sucking money out of the estate. Now, that is Gemini, not me. That is not me. I have nothing to do with those. So interesting. Again, if you want to go back and watch the last live stream, at least the first 5 minutes, and see the jokes that Claude put out compared to Gemini, it's an interesting contest. I will try all sources of AI, and we can compare and decide who because this is the most important thing. Who cares about, chips and data centers and biotechs and space travel. We want to find out which AI model will produce the funniest jokes, because that's really the most important thing. At least I think so. So I think I mentioned the last time, there's a status conference coming up in GTII. In other words, there's a hearing in front of a judge, and the judge kind of asks what's going on. And we've been having these monthly for about the past 6 months. There was a bigger gap in time before that. And we're tracking the audit amongst other things. And in preparation of this June, and again, this is just my opinion only, take it for that. You can have a different opinion. You might think I'm a moron, and you might be right. Or you might think that, there's different explanations for things. Again, feel free. Don't be bound by anything I say or write or submit to the court. It's just my opinion. Trying to, I'm not trying to say anything that's untruthful, so you could take it as such. So I filed something on, I believe, the 25th of May, so Monday or Tuesday of this week, and it was a declaration regarding the upcoming status conference. And like, I try to keep things, especially in this courtroom, short and to the point, because I'm not sure, how much they're being read or considered, etc. So as a result, I don't want to, if somebody's actually reading them, I don't want to give them reason not to read it. So I try to kind of keep it short and sweet. So I explained that and I'll read from some of it. It's not because it's not long. I explained that, I'm a shareholder, and I have I'm just going to read. So paragraph 1, during the course of the receivership, I have offered many concerns to the receivership with regard to the handling of the audit and other issues. Up until the time that Barton quit recently, my accurate concerns were ignored. That has left shareholders in a more vulnerable position, especially since there is almost no cash left. 2, I am concerned now because of the lack of cash that the receivership might engage in settlements that are motivated by principles about paying the professionals and themselves, rather than acting in the interests of the shareholders and equity. In light of all the facts raised by the receiver as to tortious misconduct undertaken by prior management and the recent disclosure of 15 Alpine accounts, it may simply be unethical to engage in settlement with remaining defendants or third parties where that party receives any financial consideration. My concern is that the receivership, in its grounds for settlement, will attempt to minimize the misconduct that the receiver has asserted for the last 20 months. And I'm going to go through these points after I read it. 3, one of the issues of concern that arose recently was when the receiver in court referenced the low cash position of Gtii, approximately $10,000, in the context of the need to complete an audit that Barton estimated would cost approximately $250,000, including the current year. When faced with the question of how GTII would pay for it, the receiver vaguely suggested money could be borrowed, or words that I understood to that effect. If money could so easily be borrowed, then that provides more reason for not engaging in liberal settlements with parties that the receiver has already targeted. 4, a long time ago, the receiver presented a transaction to the court involving some combination with AI-versity. Later, but many months ago, the receiver seemed to indicate that the deal was off due to a change in terms dilution. Yet, the receiver has yet to state that the deal is off or still on or move forward with it in any public way with the court. 5, and last paragraph, before I kind of go through it and just kind of tickle them a little bit. Additionally, by keeping transactional status unreasonably ambiguous, especially in the light of what happened with regard to the audit, the receiver has unwittingly likely discouraged other potential suitors. It is unlikely that anyone or any entity is going to be willing to spend the money or due diligence without a pending transaction, already slated. This is especially true in light of the condition of GTII and its lack of anything but issues. If nothing else, the lack of clarity negatively impacts GTII's ability to attract some form of transaction. Then I sign it and submit it, etc. And kind of let me go through some points, and I have some other things I'm going to cover about my conversation with another large, not another, but a very large shareholder. So kind of just going through it and kind of referencing it. So I say I kind of like, I have been throwing off concerns to the Receivers Council, and I have probably for 18 months. Some of those concerns were completely ignored, for example, up until recently when they decided to take a much more aggressive stance. The short position, et cetera, was completely ignored. When I asked for intervention with regard to the audit many months ago, completely ignored and dismissed, and they said it wasn't appropriate to interact. And obviously, in my opinion, audit was completely mismanaged. So now apparently they've taken attention. That's why the Barton firm was, they quit. And then we had the receiver pick the Florida firm that he said he had been working with for 2 years. And then the question came up, if you're working with the firm for 2 years, then why, like a year and a half ago, didn't you select that firm that you are now praising to do the audit originally? And we would have been done with the audit. And if you remember, Claude said that was the biggest failure of the receivership, is the inability to get everything right with regard to the SEC and the audit. And it was pretty clear that was a huge failure. At least Claude thought it was a huge failure. So it didn't make a lot of sense to me that when the most recent, or I think it was the most recent hearing, the receiver said that they'd been working with the new auditor for over 2 years. They were great, whatever. But when he had a chance to select that team, he didn't. Obviously, well, in my opinion, it's been poorly managed, and that is just another example of a bad decision in the handling of the audit, which Claude says, and I believe, is paramount to getting things done, and was the primary responsibility of the receiver to get it done. He has an expert forensic accountant on his team, and somehow still he's managed nearly 2 years later not to get it done. So I'll just leave it at that. I'm not attributing any intention. I'm just it is what it is. 2 years in, and it hasn't been done. Now, on top of that, the auditor they put in place, which is now going on probably like 2 to 3 weeks, the receiver represented a month before that it would take the new auditor about 120 days to complete all the work, including the year, I think the 2024 or 2025 year. So the years that hadn't been finished plus another year. And the receiver indicated in open court 120 days. So maybe we're in 40 days, maybe we're in 20 days, but let's see after 120 days if everything is done, or if we're having this conversation again and I'm pissy and bitching about a further aspect of the audit. I would really be annoyed, and the court, maybe, I don't know what the court will be, but everybody, I think, should be annoyed if 120 days pass and again there's an issue with regard to the audit. And I'm going to address this a little more detail when I talk about my conversation with the receiver. So let's see, in 120 days minus 20 days, let's say 100 days max, where we are. Second part is the cash. And
settlement negotiations. So since I drafted this, there was another extension granted by the court till I think June 30th for Reichman and the receiver to finish negotiating a settlement, and that is occurred even subsequent to the disclosure about the 15 Alpine accounts and all the issues that arose and the allegations that the receiver indicated that in a 2-week period, I think it's September of 2022, through the receiver claims, Reichman-related accounts, $60,000 became $10.8 million in GTII stock that was facilitated apparently through Alpine with Reichman's 15 accounts and whatever other shenanigans went on. So with that as a backdrop, they're in negotiations with Reichman and reads just generally, I'm a lawyer, settled a lot of cases. There's give and take. So for almost every case, you may not get 100%. And so somebody who arguably won't be deserving of something will get something because that's what the price is to get paid. But in some circumstances, maybe that's not correct. So for example, and I might have used this before, but would Bertie Madoff be entitled to some shares, to keep some shares because it was more complex not to give him shares? I think there's under some circumstances where someone is an absolute scumbag that perhaps they shouldn't get anything out of the deal and there has to be a line drawn. And even notwithstanding cost, perhaps there sometimes has to be a line drawn. And the reason why, and so typically I wouldn't take that position. I take a much more practical position. And I don't know what the deal will be between Reichman and the receiver, but I'm concerned about Reichman getting anything significant of value. I'm also concerned, and it's also referenced here, that because money is owed to professionals and needs to be raised for the auditor, that the receivership will cut a deal with a scumbag to raise cash that will pay the professionals that the receiver will take a cut of, but it won't really benefit us, because for us shareholders, what we need is completion of the audit and some transaction getting done. And what do I know as of today? The audit is in shambles. The receivership has very little money, but says it can borrow money, and there's no transaction. So I'm concerned that the receivership will entertain a settlement to raise cash for the receivership estate that won't go for the benefit of shareholders, but in turn will pay the lawyers and pay the receiver because he gets 10% of the cash brought in. Now, again, ordinarily, I wouldn't push too much on that, but the receiver said he could borrow the money to pay the auditor. And we know that when the estimates for Barton came in related to completing the audit and the current audit, that was 200 approximately. 175 plus 65, I think. And, again, whether that was, and I think that was below market. So that would be like 250 grand. So when the receiver communicated with the court that they would be able to fund the auditor, and there was no money in the account, but he kind of intimated that they could borrow the money. Well, if they could borrow the money, they should be able to borrow the money to pay the auditor and the legal fees. And if they need not to accept a deal with somebody that they label, a tortious actor and a scumbag, my words, then they shouldn't be engaging in settlements with any person like that, because we need to draw an ethical line here at some point. And if the receiver has money or assets to pursue that person and give them nothing, that might be the better choice. Just my opinion. And again, that's different than I would normally say, because normally it's give and take. And again, I haven't heard what the deal is. All I could tell is they keep on negotiating it. Sounds like the U.S. and Iran, honestly. They keep on negotiating it, but they can't strike a deal. And it doesn't seem like the party that they're negotiating with is in really good position, considering what the reports of the receiver were. So if the deal is not extremely skewed in the benefit of the receivership, I would be really disturbed and annoyed. I'm just stating that up front, so it's not a surprise. And I'm also stating it up front so the receivership hears this and understands that's what's coming. And, I expect they're going to, because I think they do, I expect they will try to justify any settlement. So I'm just putting in the context that you've kind of set the table about who you're settling with and all the issues, and it's going to be closely scrutinized, because again, I don't want a settlement with Reichman just to pay the lawyers and pay the receiver and screw the shareholders. I want to see activity. And again, the only activity that means anything to the shareholders, bringing back shares is great, but no audit and no business is the key material things. If we don't get those, then this company ain't going to ever trade, and we ain't going to get $1 out of that. So doing their job, such as the receivership is doing in terms of bringing back shares and chasing people down, that's wonderful, and I'm not going to criticize their success. But for shareholders, that's bullshit, and it means nothing. It's the audit and a business, those two items. Without those two items, for us, what the receivership has done to this point in time is just kind of torture shareholders by dragging it out, by not completing the audit in a timely fashion, contrary to what the original receivership order stated in September of 2024, and what a bunch of interim reports of the receiver stated. That, in fact, there were numerous reports, and I've gone through them ad nauseum, where the receivership indicated that the audit was going to be done in 30 days, like 12 months ago. So, whatever. In my mind, we need to watch out for the settlements. We've got to make sure they are appropriate for the parties and not based upon a situation just to pay professionals. And we have to make sure the receiver completes the audit and gets a deal done. And, those are two areas. And again, for us, that's all that matters. The other stuff is BS. But for the audit and a deal, we go nowhere. And the receivership has to know and understand that. So we don't give a crap, in large part. Makes no difference to us what they do otherwise, because that benefits a bunch of other parties other than the shareholders. If, in fact, an audit is done and a transaction is done and GTII trades again in some fashion, then bringing back shares and getting rid of, in essence, dilution, that is positive. But until that is done, that just lines the pockets of other people, not shareholders. So that is that. And in one of the paragraphs I reference is the AI-versity deal, and it kind of relates to that. So AI-versity, the receiver was, hot on that deal, and then it kind of fell by the wayside, and then either in reports, the interim reports, or in court, or both. I think it's both. The receiver indicated, that that deal had kind of gone south. Terms had changed. There was, apparently a great dilution or potential dilution, and it sounded like the deal was dead. But that hasn't been presented, as far as I can tell. That has been presented to the court. And as far as the court is concerned, there is a pending deal. And perhaps as far as somebody else or other entities that might be interested in engaging in using GTII for their purposes and getting it traded again, why would they spend a boatload of money in due diligence when they don't even know if there's not a deal pending, if they have a place? Because why would they spend a bunch of money while there's a pending deal? Until there's not a pending deal, I would think somebody would be cautious. If somebody came to me, that's kind of the advice I would give them. So it makes no sense to me, amongst other things, why the receiver is not, who again, expressed clearly, I think, that they weren't going to do the AI-versity deal. At least that's what they said. At least that was my impression of what they said, and they've been mum on it since then. If that's the case, and they haven't been communicating with them, and they haven't indicated they've been communicating with them, then just take the deal off the table. So you will invite other entities or parties or dogs or cats to make offers or to engage in communications with the receiver. And again, the reason why this is kind of an annoying issue, and it shows a complete lack of understanding of the context of this issue, is this is what GTII was accused of doing all those times. They would enter negotiations with some deal, and the deal wouldn't happen. And it looked like after you do that 5 or 6 times, it looks like BS. It kind of looks like a pump and dump, to be honest. It looks like perhaps maybe you're engaging in communications about a potential deal, but you really don't have an intention to complete that deal. And when you publicly announce you're engaged in communication with company X, that might positively impact your stock, and maybe you would sell the stock at that point in time and be able to generate a large return. Anyway, so, but without kind of clarity here, we're kind of stuck in place. And again, Claude said this, and I say it. The 2 most important things that we need to be able to trade and for shareholders to get out of this mess or get something out of this mess is to get an audit and all the SEC stuff cleaned up. Whatever needs to be cleaned up needs to be cleaned up. And that's what a pledge the receiver took September 24. And as far as I'm concerned, none of that, or basically none of that's been cleaned up sufficiently. And obviously a deal. Without a deal, what do we got here? We got an empty shell with garbage that, according to the receiver, had less than 10 grand. I don't think it has any other assets, as far as I know. Doesn't own property, as far as I know, even though perhaps it should. It doesn't have any intellectual property, as far as I know. Perhaps it does, but I don't know about it. So it doesn't have a lot. So without a deal or transaction, we got nothing. So prove me wrong, Mr. Receiver. Get the audit done and get a deal done, and stop focusing on issues that are less important to shareholders. Bring back cash, it definitely does not benefit shareholders. It only benefits the professionals and the receiver. Bringing back shares might benefit shareholders, but it won't benefit shareholders at all unless GTII trades in some fashion and there's an audit done and a business comes in. Otherwise, it's all BS. And then the only parties who will have made money are the lawyers, the accountants, and the receiver. And that's it. And that would be a disgusting conclusion. All right. So gone through my declaration that I filed and kind of like notated. I like that word, even if it's not a word. I noted kind of where I pop in there. So what I wanted to now reference and kind of leave that as the end is out of the blue, I got called this week from a large shareholder, might be amongst the largest shareholders. I don't know what position they have with regard to the lawsuit. I don't know if they're a party to the lawsuit, but they have an interest in it, and they're following. And one of the questions this person asked me is why I'm continuing to work on this. And it's funny when people ask me, like, that's like if you make a pledge to do something, then you follow through, and that's kind of what I said. But anyway, it's just funny when you're being asked that, why are you continuing to do that? And I explained it. But we had a discussion about the status of GTII, because he's still very interested in it. And his opinion and this is not something I volunteered, so it just came out in our conversation. His opinion and his concerns that he expressed to me is that the receiver is just basically extracting all the cash and assets out of the receivership estate and leading it to bankruptcy, and then he'll be done. And now, did the person who I spoke with have any concrete evidence of that? No. Nothing more than, just examination of the record and what has gone on to date. His concern about the audit also, or the lack of, but he expressed concern about whether the receiver was just there to basically drain the assets. And again, he gave no specific evidence of it other than what has occurred in the receivership. And again, my prior experience with receiverships has not been great. You have to watch over them because they have a tendency of extracting the cash from the receivership. That's been my experience. Now, they may also accomplish positive goals, but that certainly is my experience. But the fact that this large shareholder was concerned about the intention of the receiver kind of, goes along with all our concerns about the intentions. Because as I sit here today, notwithstanding the performance of the receiver in terms of bringing back shares and cash, etc., I still do not, as I sit here, one, I don't feel comfortable. I could comfortably say that the receiver has significant concerns about shareholder benefit. I don't. I can't say that. So can I absolutely say that the receiver that they're absolutely not just draining the assets out of the receivership? Well, you can see that they have to this point in time, because there was cash before the receivership, and now there is not. Now, there is a bunch of shares that have been canceled or brought back, so that is the consideration. But if you were just kind of being literal about the question whether the receivership has drained cash, it has. There's no doubt about it. And if more cash comes in, that will be a further drain on the receivership. Now, I don't really give a crap, by the way. I honestly don't care about that unless there's no audit completion, there's no deal completion, and we don't trade again. Then I would care a lot. Now, it's not saying that we would have ended up in a different spot anyway, because, I think this company, as of, 2024, it was headed to BK court anyway, I think. And I'm not saying it's headed that way at this point in time. But if, in fact, we don't get the audit in short term, and we don't get a deal done in short term, and we don't get back operating, then the only conclusion I will be able to draw, and it might be a wrong conclusion, is that the receivership drained all the assets out of the estate. So we will see, because we will let the record speak for itself, and we'll let the performance of the receivership speak for itself. And, we either are going to get a completed audit and a deal, or we won't. And that will, and and we know at least one deal has been presented to the receivership, because they've expressed that already, that happened. And my understanding is there may have been other opportunities or inquiries too. So let's see what happens. And I will be the judge, even notwithstanding my skepticism about the receivership and the skepticism of a large shareholder. Let's see what happens. Let's see what plays out. And last but not least, about the Alpine and the shorting and the DTCCCC. By the way, I always say that because I don't know how many C's there are in DTCCC. So just to remind everybody, Alpine, according to the DTCCC, had a concentrated short position in GTII. And ironically, as it turns out, later disclosed, but not seemingly disclosed in the DTCCC opinion, not reflected in anything I've heard from the SEC, but Alpine had apparently 15 long Reichman-related accounts sitting in Alpine at the same time. And that's not reflected in the DTCC footnote that talks about the concentrated short position. I don't know if that would have changed their opinion, strengthened their opinion, led them elsewhere to further investigate. I mean, I welcome their investigation of the individuals. I mean, if in fact what the receiver has said about the principles of GTII are true, then the feds should be all over them. Again, you know, if what the receiver says is true, then it seems like a straight out scam, and that's what the receiver claims. If that's true, I don't know why the feds wouldn't go after this, because it seems like a slam dunk, and it has nothing to do with the company. It would have to do only with those people that the receiver has specifically targeted at the top and remain there, and who, according to the receiver, have extracted a lot of money out of the receivership, including but not limited that move from $60,000 to $10.8 million in September of 2022. So time will tell. And my concern about Alpine and what the receivership is doing there, and again, time will tell on this too, is I'm concerned that this is just a BS move, a way to placate shareholders without any real intention of accomplishing anything or pushing aggressively. That's my concern, and we'll see how it plays out. Again, I want to be proven wrong as to everything I've said here today, because if I'm proven wrong, then we all win. If I'm proven right, it just makes me smart but poor. If I'm proven wrong, it gives us an opportunity to get out of this mess. So that's where I'm going to leave it for today's purposes. Next hearing is June 17th, which is about 2 weeks. At some point in time, we're going to see, since it's reflected in the court filings, at some point in time, I would expect within the next 2 weeks or less, we will see some prospective settlement with Reichman and perhaps others. And as soon as I see that, I will report on it and we can discuss it, and I could opine and bitch about it. You can do the same. I could then, assert my opinion. You could assert yours, and we can go from there. And again, let's keep track of the audit, and let's make the receiver entertain other offers and move transactions forward if in fact he's not going forward with the AI-versity deal, which is every indication he's given. So let's push on that if you agree with me. And that's it. Have a great Saturday. Beautiful day out here in SoCal, warm and blue skies. And that's it. So everybody have a great day. Take care of yourself. Take care of everybody else. Say hello to everybody. Be well, and see you soon. We'll talk to you.